Commend it to the House.
Honourable Phil Goff.
Mr Speaker, the previous speaker mentioned that there were 18 justice bills that went through under the last term of government. That may well be the case, but one should never mistake quantity for quality. And the bills came in two separate categories. The first category that was passed was, and the one that we got most used to, was the sort of populist bill that spoke a lot about an issue but actually did very little about it. And the origin of those bills were in the National Party Research Unit, and the research they were based on was polling. Did people feel that might be a good idea? And if it looked like there might be some popular support for it and it looked like it might do something, then the bill went through. Now, I've got to say, Mr Speaker, those sort of bills are useless. They waste our time, they create the impression with the public that something is happening when it's not happening, and they don't actually go to the core of the problem of law and order, which is about keeping the community safe. The second form of bill is a bill that usually has its origin in the department that sponsors it, either the Department of Justice or the Ministry of Justice or the Ministry of Corrections, as is the case with this bill. They, Mr Speaker, tend to be practical bills. They're based on research, they're based on experience, and they're based on doing something about the problem of crime in the community and actually making people safer. Now, I believe that this bill is largely in the second category, and that is why the Labor Party will be supporting this bill through to the Select Committee. And I strongly suspect that we'll continue to support the bill because, having read through the bill, there are a number of practical and quite technical changes that are being made. And the Select Committee will, I think, operate in the way that Select Committees operate best. We'll look at it objectively. We'll see whether the bill achieves its purpose. We'll listen to the submissions. We'll analyse those submissions, and we'll do the right thing for the country. The goal of the legislation is to provide a sound framework within which the Corrections Ministry and system can operate, and nobody can be opposed to that goal. The objective set out in the bill is to manage offenders in the community in a way that's safe, secure, humane, effective and efficient. And I think that those are proper objectives. And I want to come back towards the end of my comments about the whole nature of community sentences, because I am a believer, a strong believer, that community sentences should be used in appropriate cases where there is no or very little risk to the community, and in place of short-term prison sentences, which I believe achieve very little. The Department of Corrections, way back in July 2010, produced a regulatory impact statement to help inform the major policy decisions that are made in this bill. And they propose changes to 3 acts: the Bail Act in 2000, the Sentencing Act of 2002 and the Parole Act of 2002. And I have some affection for those acts because those were acts passed when I was Minister of Justice. They are major pieces of legislation. They shape our justice system today. They are important pieces of legislation in terms of modernising how our system works. Mr Speaker, they were also bills that were based on a rational assessment of how our justice system was working or failing to work. They weren't based on simply populist thinking that this seems like something that might be what the electorate would like if they're worried about crime. The great thing about those 3 pieces of legislation is that after a decade in operation, nobody is saying that they are in any way fundamentally flawed. 10 years on, we got that legislation about right, and that's quite a remarkable achievement because of the complexity of the situations that we are dealing with. They have indeed stood the test of time. However, over time, a number of minor and technical changes have been discovered as being necessary to make those pieces of legislation work better, and those minor and technical problems are identified and addressed in this bill. They will, I believe, improve the operation of home detention and community-based sentences and the electronic monitoring regimes under which offenders are managed. The technical changes are required largely to deal with operational procedures where the legislation is either silent or it's unclear or it's been interpreted in ways that were not what was intended in the framing of the original legislation. So the first changes to the Bail Act and the home detention sentences under this bill will continue to run when an appeal is lodged. And I think that's sensible because the person is within their own home where they're being detained. An appeal may be lodged, but you would not suspend the conditions, the restrictive conditions, while that appeal is being considered. Most of the changes under the Sentencing Act, for example, requiring pre-sentence reports before an offender is sentenced to home detention or community detention, I think that is simply a matter of common sense. When the judge is making that sentence, the judge needs to have the best information possible. It clarifies the maximum number of hours that an offender is required to serve. That's a technical matter. It clarifies the effect of a subsequent sentence of imprisonment on the sentence of home detention. At the moment, if you're sentenced to imprisonment, then that brings to the end the sentence of home detention. But the sentence of imprisonment might only be for a couple of weeks. And actually what the offender requires is a longer period of supervision under restrictive requirements under home detention. I support that change. It clarifies the situation where there's more than one community sentence in operation. That makes sense. It speaks for itself. It enables court registrars to issue warrants in applications to review a non-custodial sentence. It provides that time stops running when an application is made to the court to vary or cancel a sentence when the offender is unable to or fails to comply with the sentence. At the moment, if you abscond and you're not serving the sentence, the clock keeps running and you get a discount on your sentence, and really that's not very smart. So I think that change is a good one. In terms of electronic monitoring, you've got a bit of a discrepancy that sometimes you're sentenced to home detention in your home, but the electronic monitoring regime is not the same as the boundaries of your home, so it's important to get some alignment between those two. Finally, in relation to parole and extended supervision orders, it clarifies responsibility for preparing reports on suitability for residential restrictions. That makes sense. It eliminates gaps in extended supervision order provisions. Most, Mr. Chairman, of those provisions are sensible. When we extended home detention after the trial period that it went through, there were a lot of sceptics and critics around New Zealand who believed that simply locking offenders up in prison was the thing to do, even for short periods of time, and that eliminated the risk to the community. I believe those critics, Mr. Speaker, were very short-sighted. The Ministry of Justice did a review into the sentence of home detention, and I think those findings are findings that everybody in this House should take on board. First of all, there is dramatically less recidivism when an offender is serving a community sentence compared to a short prison sentence of pretty much the same time period. About 22% on community sentences were reconvicted after 12 months. If you look at the reconviction rates for people on very short-term prison sentences, that figure is twice as much. It's over 50%. Clearly, we want sentences that work. In relation to costs, it's about $58 a day to keep somebody under Home D. It's about $249 a day to imprison a person. So less recidivism, less cost, but I think the other argument is even more important. It keeps the offender, who is at the lesser end of serious offending and is not of risk to the community, in the workforce, maintaining his or her job and maintaining their responsibilities in the home environment, which is something that prison interrupts. So I think that community sentences, Mr. Speaker, should be fostered. They're important, and it's important that we get them right. I think this bill is a step in the right direction.
I call David Clendon.
Thank you, Mr Speaker. Mr Speaker, I'm pleased to take the call on this, and I'll just pick up on some of